With the playoffs going on, one of the biggest talking points is the lawsuit 2311 Racing and Front Row Motorsports have filed against NASCAR. We heard statements from the owners of 2311 Racing and Front Row Motorsports, but now we've finally heard what NASCAR has to say, and they just gave a brutal response. In October 2024, 2311 Racing, co-owned by Michael Jordan and Denny Hamlin, and Front Row Motorsports filed an antitrust lawsuit against NASCAR and its chairman, Jim France. The lawsuit challenges NASCAR's business practices, particularly regarding the charter system that governs team participation in races. Both Front Row Motorsports and 2311 Racing are looking to remain on the NASCAR grid under the 2025 charter agreement. Once a new agreement is finalized, all the teams will transition to the new terms and conditions. Now NASCAR has come up with their own reply to this. Here's how NASCAR responded on the court documents. Defendants are working to prepare oppositions that provide argument, applicable law, and evidentiary support to demonstrate defendants' positions. 1. Plaintiffs are seeking a mandatory injunction that is only warranted in the most extraordinary circumstances, which are not present here, since they are seeking to alter the status quo through an injunction requiring NASCAR to provide charters for 2025 and beyond, notwithstanding that the time to sign charters for 2025 has expired. 2. Plaintiffs cannot establish irreparable harm since plaintiffs and their counsel have confirmed that plaintiffs' teams will compete as open teams in 2025, which means that money damages can compensate plaintiffs even if they were to ultimately prevail. 3. Plaintiffs cannot establish a likelihood of success on the merits for multiple reasons, including that this is a dispute over contract terms, not an antitrust case. This passage lays out the key points of the defendant's argument in opposition to the plaintiff's request for a mandatory injunction in a legal dispute related to NASCAR charters. Let's break down each of the 3 points. 1. Mandatory injunction in extraordinary circumstances. Plaintiffs are seeking a mandatory injunction. This is a court order that requires a party to take action, as opposed to a prohibitive injunction, which prevents a party from doing something. A mandatory injunction is more difficult to obtain. NASCAR claims that this is not an extreme case, given that only 2 out of 13 teams have filed a lawsuit, while the rest of the teams have signed the charter agreement. Only warranted in the most extraordinary circumstances. The defendants argue that courts typically only grant mandatory injunctions in very rare and extreme cases, which NASCAR is claiming is not this case. Plaintiffs are seeking to alter the status quo. Instead of maintaining the current state of affairs, the plaintiffs are asking for a change, specifically for NASCAR to grant charters, licenses that allow teams to compete. NASCAR to provide charters for 2025 and beyond. The plaintiffs want NASCAR to issue charters for future seasons, including 2025. The time to sign charters for 2025 has expired. The defendants claim the deadline for issuing or signing charters has already passed, which strengthens their argument that the plaintiffs are asking for an unusual and disruptive remedy. The defendants argue that the plaintiffs are asking for a mandatory injunction to force NASCAR to issue charters after the deadline, which is a request only granted in rare, extraordinary situations, and this case does not meet those conditions. 2. No irreparable harm. Plaintiffs cannot establish irreparable harm. The defendants argue that the plaintiffs cannot prove they are facing harm that cannot be fixed with money or other remedies. Plaintiffs and their counsel have confirmed that plaintiffs' teams will compete as open teams in 2025. The plaintiffs have already acknowledged that their teams will still participate in the 2025 season, though not as charter teams, but as open teams. Money damages can compensate plaintiffs. The defendants assert that if the plaintiffs win the case, any harm or loss they suffer can be compensated with financial damages, which means there's no need for an injunction. The defendants argue that the plaintiffs can still compete in 2025 and can be compensated with money if they win, so there's no need for urgent action like an injunction. 3. No likelihood of success on the merits. Plaintiffs cannot establish a likelihood of success on the merits. The plaintiffs are unlikely to win based on the substance of their legal claims. This is a key factor in obtaining an injunction. If a court believes the plaintiff is unlikely to win, it won't grant an injunction. This is a dispute over contract terms, not an antitrust case. The defendants argue that the lawsuit is about interpreting a contract, likely related to the charters, and should not be treated as an antitrust case. Antitrust cases involve claims of unfair competition or monopolistic behavior, which might warrant different legal treatment. The defendants claim the plaintiffs are unlikely to win because the case is about interpreting a contract, not a broader issue of antitrust law, and this weakens their case for an injunction. The defendants' opposition to the injunction is based on 3 key points. 1. Mandatory injunctions are rare and not appropriate in this situation. 2. The plaintiffs will not suffer irreparable harm because they can still compete and be compensated financially. 3. The plaintiffs are unlikely to win the case because it's a contract dispute, not an antitrust case. In the past, we've seen NASCAR handle similar things with a bit of do-or-die policy. Back in 1961, there was one driver, Curtis Turner, and his business partner, Burton Smith. Turner tried to form a union with Smith. They sought help from the Teamsters Union to form the Federation of Professional Athletes, or FPA. However, Bill France Sr. was not happy with this at all. Given that NASCAR has always been a private company, they can operate as they wish. And Bill France made it clear that any union-affiliated driver would not be a part of the NASCAR grid. The rest of the drivers quickly fell into line in fear of not being able to race in NASCAR. A similar thing happened in 1969 when Richard Petty and a few other drivers decided to boycott a race. France Sr. just got other drivers to fill the empty seats and continued on with the race. Bill France Jr. could be looking to do the same thing here as well. With 2311 Racing and Front Row Motorsports having filed a case, France Jr. could ban them from the 2025 grid, as they would not have signed the charter agreement yet. This could scare the rest of the teams off joining the lawsuit, and could even cause 2311 Racing and Front Row Motorsports to drop their lawsuit. But the two teams have also shown some stubbornness from their side, which could result in a battle. Ever since the start of the negotiations, Denny Hamlin has been vocal about what he and the other teams are looking for in a new contract. They wanted the teams to earn more money and have more control in the sporting rules and regulations. However, NASCAR has said that they will not do so. Front Row Motorsport and 2311 included a list of what they called anti-competitive practices from NASCAR leadership: buying a majority of the premier racetracks that are exclusive to NASCAR races, imposing exclusivity deals on NASCAR-sanctioned racetracks, acquiring Automobile Racing Club of America, or ARCA, the only notable stock car racing series competitor, preventing teams from participating in any other stock car races while also retaining ownership over next-gen parts and cars, forcing teams to buy their parts from single-source suppliers chosen by NASCAR. However, NASCAR is not willing to succumb to these demands. They want to retain control of the sport and govern it as they see fit. So they want to retain the majority of the revenue instead of sharing more with the teams. Ideally, it's in NASCAR's best interest to settle the case outside the courtroom. If things head to the courtroom, anything can happen. Besides, the financial records of NASCAR, which used to be private, will suddenly become public. This may not be the best thing for NASCAR, as they will not want to reveal how much revenue they generate in the season. If that is revealed, more teams will find their fee unfair and demand a larger piece of the pie. 2311 Racing and Front Row Motorsports have hired Jeffrey Kessler to represent the teams. He'll be taking on NASCAR in this lawsuit. Here's what he had to say about the lawsuit. There is no other major sport where one family has run that sport as its own personal fee stub and piggy bank, the way that NASCAR has been run, Kessler said. We will see what impact that has in terms of how they tried to defend themselves. We will see what impact that has in terms of whether it's possible to settle this case, or whether we have to take it all the way through trial. Either way, we're prepared to do what's necessary to effectuate change. An antitrust lawsuit against NASCAR would not only pose financial and operational risks, but could also weaken the entire structure of the sport. The centralized model that has helped NASCAR maintain its identity and market power could be fractured, leading to long-term challenges for both the organization and the broader motorsports industry. What are your thoughts on the lawsuit filed by 2311 Racing and FRM? Post your thoughts in the comments section below.